Right, well, thank you very much. So welcome everyone to the 6th seminar of the International Interdisciplinary PhD in Progress seminar series, which is already in phase 4 and which is organized by the Global South Network. I'd like to just start off by thanking Norman, who all of you know, who is the organizer of this seminar series. He's a lecturer here at Leicester Law School and the founder of the Global South Network. Now, my name is Francois Du Bois, and I'm a professor here at Leicester, and I'll be chairing today's session. And I'm going to be joined by 3 discussants. The first discussant is Dr. Chen Zhu, who is an associate professor at Birmingham Law School and teaches and researches intellectual property law and informational jurisprudence. He's done a broad range of research, and his published works cover a diversity of areas such as the theory and practice of software licensing, music copyright, and the legal regulation of sports sponsorship. Our other discussant is Dr. Pinar Oruc, who is a lecturer in commercial law at the University of Manchester, where she specializes in intellectual property law and is also co-director of the Center for Law and Business. She earned her PhD on copyright law and cultural heritage at Queen Mary University and was also a postdoc researcher in Glasgow, where she worked on a project called Recreating Europe, focusing on AI, text and data mining copyright, and is at the moment finishing her monograph entitled Digitizing Cultural Heritage, Clashes with Copyright Law, which will be published by Hart. And then we also have a peer commentator as always, and today's peer commentator is Jose Camarena Lopez, who is a PhD candidate at the School of Law at City University of London, and who specializes in the intersection of data policy, regulation and copyright law. He has long experience in private practice as well as in teaching. He was a partner at a private law firm in Mexico and held various positions in the Mexican public sector, including roles which focused on industrial property, intellectual property, and he was a professor of law at the Monterrey Institute of Technology in Mexico. It's Mexico's top-ranked private university before he came to work on his PhD in London. And then last but not least, of course, our speaker today is Jackie Yiheng Liu, and he is a doctoral researcher on intellectual property law at Queen Mary University of London, who focuses on moral rights in relation to artificial intelligence creations and exploring generally the legal challenges posed by AI-generated content. And his talk today is entitled Whose Code, Whose Creation? Examining Copyright Authorship Attribution in Artificial Intelligence Generated Content. So, Jackie, you'll have 30 to 35 minutes for your presentation, and that will then be followed by 5 minutes for each of our commentators, discussants, and then if time permits, we will hopefully also have time for a Q&A session to broaden the discussion to all attendees afterwards. But Jackie, the floor is yours now.
Thank you very much, and my name is Jackie Han Liu, and yeah, as we mentioned before, and I'm a doctoral researcher at Queen Mary University of London. So today we are talking about one of my research proposals for the next stage of my research. So I would highly appreciate your feedback, and we can discuss about the potential adjustment of this research, and even furthermore about the furthermore about any content of AI and copyright law. Yeah, let me begin with self-introduction. And I am now conducting the research around AI and moral rights, and I finished my LLM from the University of Manchester, and I did that with Dr. Pinar Oruc, and it's really nice to see you again, Dr. Pinar. And after which I finished my engineering degree from the University College London. So for today's speaking, and I'm going to break my session into 5 different parts, where from the background to the final or the future ideas of the research. So let's begin with it. So in this research, I would like to start it with this comic book. This comic book named Zarya of the Dawn. This is created by Camarena from Midjourney. Oh my goodness. This is created by Camarena, created with the AI model named Midjourney. And when Camarena applied for the copyright registration from the US Copyright Office, and it was initially approved. However, when the US Copyright Office found that this is actually created by the generative AI, and they cancel the registration and says, no, this cannot be the copyrightable work, and you should not be the author. So here comes the research questions of this topic. How can we identify the authorship in the AI generated content, or what could be, or who could be identified as the author of the AIGC? So for the background, we all know that recently there is a lot of AI models such as ChatGPT, such as DeepSeek. They are all rapidly developing in our daily lives and into different sections such as arts, science, and technologies. And all of these are pushing the boundary of what a machine can create. And when we further discuss this into the authorship challenges in the copyright law, this raises another challenge about the boundaries between the human authors and the machine authors, who could be identified as the author of the work. So for the most of the countries in the world, the copyright of AIGC is denied. It's not accepted in most of in major countries such as the US, such as Australia, and so on. However, in some of the countries like the UK, we accept AI generated work, or we say computer generated work, as special categories in the copyright law. And the authorship should be attributed to the person who makes the necessary arrangement of the creation of the work. So here comes the questions. What can be identified as such necessary arrangement, or who could be identified as such person? The sufficient contribution to the creation of the work. How to identify this level or this degrees? There exists a certain ambiguity within it. So to further show this topic, and we have these pictures shown on the screen. This picture is created by me, but actually it's not by me. I use the image generation model named DALL-E released by OpenAI, and I merely use a prompt like this shown us on the screen, create a religious oil painting in the styles of Jean Vermeer, and this is what I got. So based on this simple prompt inputted into the AI models, and I can generate such pictures with high qualities like that. So in this creative process, who could be identified as the author, or my contribution of this prompt, whether it can be the sufficient arrangement, the necessary arrangement of the creation of the work. There is a question mark within it. And around this question mark, there exists two main ideas around the authorship of the AIGC, including the programmer and the users. So firstly, let's discuss about the programmers. So some of the academia believe that the programmers are infusing their creativities into the AI through the program designing and decision-making process, that they will affect the creative process of the AI, so that it seems reasonable for the programmers to be recognized as the author, because they have the creative contributions to the foundation aspect of the AI technology, although there's no direct link between them and the AIGC. However, on the other hand, from the perspective of the users, some academians believe that the users have contributed to the AIGC by providing specific prompt and materials, and these materials are guiding the AI's creative output. So in this interaction between the user and the AI program, will this be reasonable to allow them to claim the authorship, because they are inputting the prompt to guide the creative process of the AI? So in this research, we can see that the users are using their prompt to influence the predictability and specificity of the AIGC, which will be discussed later about the influence of the authorship. So furthermore, let's see, beyond the dichotomy between the programmers and the users, the reality seems even more complex, because here we can see that when the user, they are using their prompt to guide the creation of the AIGC, they are partially taking over the role of the programmers, or the boundaries between the user and the programmers are blurring during the creative process of the AIGC. Let's take an example. So recently, the ChatGPT has released a new function named MyGPT, which allows any users to use their specific prompt and input them into the GPT models and repackage it as a new GPT version to publish it to the public. So in here, we can see that the users are using their specific prompt, and reprogram the AI models. They input their prompt into the code of the AI models, which means that they are partially taking the role of the programmers. So here, this situation makes the identification of authorship even more complex, because the boundary between them are not as clear as we imagined. So here we can see that the user could enhance their authorship claims by directly shaping the creative output through the detailed prompt. And even more complex, according to Alan Turing, the function or the creative process of the generative AI is just like the picture shown in the screen. The creative process of generative AI is just like a black box. that nobody outside can see what's inside, even though they are the programmers, they built such AI models, or they are the users, they input the prompt and the materials into these models, they cannot see what's happening inside, which means that the identifications for either copyright or authorship cannot based on the creative processing with what's really happening inside. So how can we make the identification? So this research is trying to propose a legal test focusing on the output and the input, since the process is unseen to anyone. So to be specifically, this legal test is focusing on the predictability of the AIGC based on the input. When we look at the input from the users, the prompt, the materials input, which is inserted into the AI models, and we can identify them in reference to the output of AIGC and see that whether it's predictable based on the input to see what we'll get in the output. So to be specifically or further explain this legal test, we have this picture. So this picture may help us to explain about the ideas of this legal test. Here we show the two different situations. The situation on the top is when the person merely uses the AI models as a tools or the instrument to create. For example, when we use AIs like Grammarly to recorrect the grammar mistakes within some text, and we have a very high predictability of the output because the output will merely be the original text without the grammar mistakes. So here we squeeze the autonomy degree of the generative AI to the minimum, and since we have a very strong predictability of the output based on the input, and we will have a very high possibility to claim the copyright protection and the authorship of the AIGC. However, on the other hand, like the situation shown in the bottom, this situation shows that when person allow the AI to create almost totally on their own, for example, when like the pictures I shown before, when we use the prompt to guide the creative process with merely like one sentence or two, please create a picture of Johannes Vermeer. And this simple prompt could create any possible pictures that out of the AI programs. So which means that we almost cannot predict what we are going to have based on our input. So here we increase the autonomy degree of the generative AI to the maximum. And since we cannot predict the output based on the prompt we inserted into the AI models, it's almost impossible for us to claim the copyright protection as the human creators, or even the authorship of the AIGC. And this legal test is not only aimed to solve this, to distinguish these two different situations, but also to solve the question mark in the middle of the pictures. When the certain portion of human contributions and a certain portion of the machine contributions are combined and mixed together, how can we identify the authorship of AIGC? So this will be the legal test, the purpose of the legal test to solve the question mark in the middle. So when we finish the discussion about the legal test proposal, and we are going to try to discuss something else, something more about the possible or the potential topic we are going to research in the future. So for the first point, since we have clarified that the reality is not as simple as the dichotomy between the users and the programmers, And when we conduct an in-depth research into the reality, we may find that the reality, including the creative process or the developing process of the AI models, it will be even more complex, because the developing process of the AI models not only includes the contribution of the programmers and the users, it also includes the complex interaction of programming, training, and data collections. And also it's supported by substantial investment. So with such a complex interaction of the intellectual, the creative, and the investment contributions, how can we identify the outcome or the authorship of the AIGC? So here we would like to propose an ideas that try to solve these problems. So since the AI operation is a complex mechanism that includes those intellectual and financial contributions, and for example the CDPA 1988 claimed that the author should be the person who makes the necessary arrangement. So we may try to propose a legal framework or the authorship framework in reference to the film industry. So as we can see that these two different industry, the AI industry and the film industry, shares a certain level of the similarities, where they all include the substantial investment and the intellectual contributions from different stakeholders and different creators. So is it possible for us to propose authorship framework in reference to the regulation of the film work? When film work firstly emerged, the UK copyright law claimed that the author should be the person who makes the necessary arrangement of the creation of the work. So can we try to identify the person who makes the necessary arrangement for the creation of the work in the AIGC in reference to the regulation in the film industries? And this would be the next direction of this research. We'll try to propose the authorship framework, consider both intellectual and financial input from different stakeholders in reference to the film industry. So finally, we would like to share the bibliography of this research, and this is shown on the screen, and we would like to give our genuine thankfulness to everyone on the screen and to everyone who attending this session. And I would highly appreciate your attention and feedback. We can discuss about any potential adjustment of this research proposal. And thank you very much for your attention. Thank you.
Well, thank you very much for really interesting, fascinating, and very well presented talk. So I'm going to turn immediately to our discussants. Dr. Chen Zhu is first on my list. So if you are ready, Dr. Zhu, please go ahead.
Okay, I hope you can hear me all right. Thank you so much for this presentation with a wealth amount of material. Yes, AI at the moment is very topical. I think just to put everything in a perspective, at the moment we have two extremes. One is a kind of snake oil AI, which will do anything, everything. And another type of extreme is a kind of a terminate type AI, which claims AI going to terminate, wipe out the humanities in any time. But I guess your research will be a sensible one. Have the research situated somewhere in between to examine the reality, what's really happening at the moment, how to which extent is the AI generated material going to affect those creators and especially their authorship. The first impression I also want to say from research, I probably future-wise we probably can put the research into a historical background, because this mechanized authorship is probably not something new now we are facing. Back in the 18th century or 19th century, when photography was invented, around about 1830s, it's debatable depending what kind of photography you are using, referring to. So there was a legislation in 1862 and the UK's Fine Arts Copyright Act, and it's for the first time introduced a subject matter called photograph, which was never properly dealt with before. So that's probably the first challenge to the copyright lawyer, and who is the author of someone who makes a picture with the assistance of the camera, which is essentially the machine. So so there are cases, I think you must know this very well. For example, Nottage versus Jackson, 1883. So the court had to decide whether the photo of a group of Australia cricket team who visited the UK, and who are the author, because the business owner sends the camera operator there who pressed the button, but the person who actually registered the copyright are the business owners. They didn't do anything in relation to operating the camera. So I think this is very kind of a similar problem we're facing now. Who is the author? So is it someone who pressed the button, or someone who makes this financially happen? So I think the result is the registration was invalidated because the business owner was not on the scene. So I would think I'm kind of inclined to think nothing is new under the sun. So it is worth making kind of analogy from the past, showing the connection, because then an unlucky judge have to make a decision one day whether a particular AI generated content will be is owned by this particular person. So, but I think it's worth considering. So because they want to make a connection with the past, because no judge wants to be overly innovative and creating something overly new. Another thing I think you probably also was thinking is the joint authorship, which is not very obvious in the presentation, but I understand you might already deal with it somewhere in your dissertation, because we have the rich body of case law dealing with joint authorships. So, for example, very recent case like Martin and Kogan. So about those collaborators, say one of them involves the early stages of drafting. So, and the Court of Appeal, so it's willing to interpret the joint authorship rather broadly to have this collaborator, although her contribution probably did not appear in the final version, so as a joint author. Thirdly, I think there are the other things. I think you have a very interesting engineering background. I think you know programming. So I'm also a hobbyist programmer. I did quite a lot of programming in my spare time as a hobby, not a professional. So I kind of mess up, kind of play with Raspberry Pi and those things. So one thing I think we can look at, say, those code generated, say by Copilot and other AI machine. So because when you go to a GitHub or any version controlled code repository, if you do a quick kind of a git log command, you will see a lot of good amount of author information. Then you can use a grep command, so you can grep author unique. Then you will find the author very roughly. So these things can be easily done with the git repository with the git command. But the problem with AI generated content, these information are very, very important. Author information get lost. So I think practically, I think your dissertation will have a profound impact on this field. So how can we address those lost author information, which can be very important assets for those human creators? Now they are used as a training data, part of the training data set, which kind of not properly recognized. So am I going 5 minutes?
Yes, we're more or less at 5 minutes, yes.
Okay, I'm more than happy to clarify anything if you want to. I'm more than happy to share the code with you if you want to do some demonstration at some point. So yes.
Great. Thank you very much. Yiheng, I don't know if there's anything you want to comment on right now, or shall we continue to our next commentator and then you perhaps comment afterwards?
Oh, that would be perfect. Thank you very much.
Okay, so thank you. So our second discussant then is Dr. Pinar Oruc.
Yeah, so thanks for inviting me. It's good to see Yiheng again. Yeah, since the LLM years, and I'm so glad you're still working on the similar topic, just expanding the topic furthermore. And you're at my, PhD institution at Queen Mary, and your supervisor, when you mentioned the film industry, I had to go back and check. It makes so much sense.
Exactly.
Yeah, but I just had general comments. I agree with the first commentator about the joint authorship and the coding issues. I don't have an engineering background myself. My entire family is engineers except me. I was a disappointment choosing law, but I just wanted to comment on a few things that was a bit of a problem. So when I was doing my postdoc on this was about 2020, 2021. So it was this brief switch between kind of GPT-2 to GPT-3, but it wasn't this mental when I was doing it. So I wanted to point out some issues about, seeing this as a point of view from a lawyer. So when you're addressing these things, I think your engineering background is definitely helpful, because one of the things I noticed when I was researching this is that we don't really speak the same language as the programmers, and we don't necessarily understand each other. And just to give an example, I went to an event a few years ago at Manchester about where engineers were presenting about whether training models themselves are protected. And they were so sure about the protection, and it should be protected and it shouldn't be taken by the others. And as a lawyer, all I thought was, is this a database? Is this a computer program? How would the models and the weighting within each layers and all the additions and contributions, how are they even going to be kind of understood and quantified by us as lawyers? How is it going to be protected? So not speaking the same language is a bit of a problem when it comes to this between lawyers and the actual technical experts. So I think your background, after the LLM, is definitely helpful there. Another thing I noticed about this research is, your research in general, it's a period of rapid change. As you know, things are changing massively. And one of the things I think is both kind of a blessing and a curse is that right now, US Copyright Office gathered opinions, and in 2023, UK IP Office is collecting opinions. They did before about AI authorship, but also text and data mining exception, and they chickened out last time when the report came out. There were promises of making big changes. It didn't happen, so now they're doing another consultation. And I think one of the kind of disadvantages is that by the time you finish the PhD, it still won't be the complete picture about how this area is going to develop. But, as the first commentator said, you can also look at past patterns and how these things developed. Another thing that can be helpful is that you can look at parties' contributions to these consultations, kind of these comments on AI cases. What did they say? What did they add to the docket as the kind of the amicus briefs? What did the experts say? Because not all of them end up in the final report. So stakeholder reactions to this could perhaps be helpful to you about, how to comment on this, how do creators want this to develop, and how the programmers react to it. And not all of them will be in the report, so sometimes it might be helpful to go through the reactions to these things. I'm sure you're already looking at those, but I think it could also be interesting to look at stakeholder perspectives. And there's also a huge kind of lobbying in the background going on about these things. So that's another thing, parties' input and period of rapid change. It could be both beneficial and kind of hard to see how this is going to go. And then the final thing, it's more of a curiosity or how this is going to develop, is that whether different industries view these things differently, because you mentioned film sector and it made me think of The Brutalist. I've been following the Oscar developments, and for them it is, we just used AI. It is AI generated, but we only played with the accents. We only improved the accents. So to them it's not AI generated, or not necessarily. So one of the things I also think about, and I'm not expecting you to figure it out, is at which point does something becomes not just edited electronically, but something anything that is AI generated, that is meddled by AI. According to Brutalist, their stuff is not, but maybe each sector sees these things differently. I mean, for them, maybe it's not AI generated, but for us in higher education, if our students use AI to write a paper, that's a problem for us. So there could also be different tolerances and different wishes across different sectors, which I find it really interesting. But other than that, these are just some of my thoughts about it. I don't really have a specific question. I think it's a good topic. It's also a hard topic, and it's hard to figure out, but I really don't think it's just prompt giver versus programmer. I mean, most of my research is about training data and text and data mining exception. So that part really matters. You know, what did they insert into the input data? Is it just trained on low quality public domain? Did they use expensive training data sets that were purchased, or was it crawled crawled and collected from the internet without any restrictions, that sort of thing? And the bias within it also interests me, and this is something that is, again, as a lawyer, I'm trying to understand, but I'm sure I'm missing some stuff. But those are just some of the comments I wanted to make. It's a bit scattered, but that's all I have so far.
Yeah, that was very helpful, I think. Thank you very much. Okay, so we have also, as I mentioned, a peer commentator, Jose Camarena Lopez. Welcome then, Jose, and please go ahead.
Thank you. Thank you. Well, thank you very much for the presentation. It's a super interesting topic for me because I'm also doing research in that area. So I just had two, well, I don't know if questions or comments, but questions. It's just, are you, in terms of scope, are you restricting yourself to a certain jurisdiction, for example, the UK law, or are you making a comparative exercise with other jurisdictions? That's the first one, because you mentioned entrepreneurial works, and that is a feature of UK copyright law, for example. And the second one is, have you thought about the possible application of performers and interpreters' rights that has been mentioned for this type of AI-generated works, no? In terms of an analogy with a prompter or a person that is a user and an interpreter or performer, and the rights that, for example, under the Rome Treaty, etc., etc. And so I just wanted to know if you're exploring also that in your research. But that's all. Thank you. Thank you very much.
Oh, thank you very much. And for the first questions, and this research is trying to focus on some specific jurisdictions. And first of all, UK, of course. And it's almost like the first legislation that recognize the copyrights of the AIGC. And secondly, we would like to make a partially a comparative research between the UK and the EU, the US. This will be three main jurisdictions that we are looking into. And one additional jurisdiction will include the People's Republic of China, because there has already existed some sentences and cases in China, although they are not very in-depth, but it worth considering in this research. So this is mainly about what we are going to include, what kind of jurisdictions we are going to include in this research. And for the second questions about the performance rights and some other related rights, the answer is yes. But the proposal or the plan of this research is we are trying to explore this on the basis of the research into the authorship itself of the AIGCs. And furthermore, we are going to try to explore any further about the possibility of the application of the performance rights, related rights, because currently I'm cooperate a paper with one of my colleagues whose expertise in the performance rights, and we are trying to research into such topic, the performance rights in relation to AIGC. For example, we mentioned about it when we apply AI technologies in the production of the movies, like Brutalist shown recently, and we are trying to figure out another paper surrounding this topic. And Yes, and this is one of my plans. Like we're firstly focused on the authorship itself, and then further goes into the scope of related rights and performance rights. And personally, I think it might be a little bit like makes the paper more fluent, things like that. Thank you very much. Thank you.
No, thank you very much.
Well, thank you to all our commentators so far. It has really contributed to the discussion, and thank you for your interesting response. There is still some time if anybody else would like to contribute, have a question perhaps for Jackie or a comment that you'd like to make, then please feel free to raise your hand, and I'll give you the opportunity to do so. Norman, yes, please go ahead.
Jackie, thank you very much for this. It's an interesting presentation. I think it was very clear for a person like me who is not very much focusing on this area of study. But I'm interested in your approach to the comparative approach. So what are the indicators? What are the determinants of selection of these cases? For the UK, EU is not like a country we are talking about. It's
jurisdiction.
Different country, different jurisdictions. And as far as I know, I think some jurisdictions do vary, and this is also part of some cases, the contestation between the local national courts and the EU courts. And then China, which is very different from these two jurisdictions.
Exactly.
So it is like least different, most similar comparative approach, or most different, least similar comparative approach, meaning thereby that is there something kind of an outcome which is very similar among these cases which you want to investigate, or similar determinants and factors which you found in these different cases which you want to investigate?
Okay, I see. Thank you very much for your questions. And regarding the selection of the jurisdictions, and these are mostly based on the specificity of the research area of AIGC, because the reason that we choose the UK, because the UK is the first countries who legislates around the AIGCs that like officially announce the protections over the AIGCs, and so is the reason for selecting the EUs, because I just finished a paper focusing on the creativity, nature of the creativity within AIGC, because we are trying to research into the in the disciplinary research area between the machine philosophy, which is coding, and the legal philosophies, which is around like why we protect the creations of the work. What is the reasons? So because the UK and the EU, they share a certain amount of the legislations, especially around the originality criteria, protect the author's own intellectual property and intellectual creation. So my like previous paper is focusing on like whether the AI artificial intelligence can be identified as the intellectual creations or the factor of it. And this is partially why we would like to choose both like the UK and the EUs, because there is a lot of things they share a certain amount of the legislations, and there is a lot of things to discuss in relation to AIGC. And for the reason why we choose the jurisdictions including the UK and including the US and the China, it's because that the US and China are like those countries have the most existing cases of AIGCs. Like in the US, there's a lot of like copyright registration issues in relation to AI, like the next Rembrandt, Cassandra Novas, like Zara of the Dawn we shown in the PowerPoint, and so on and so on. So there is a lot of existing dispute that deserves considering and discussion. And so is in China. there is already a lot of cases like Tencent versus Yingxun and the Ultraman cases, things like that. So there is a lot of like existing cases for us to discuss, although those cases are mostly based on the legal common sense instead of the in-depth research of the legal philosophy. But there are still like examples for us to discuss in this research. So this is the reason like why we choose these four jurisdictions in this research and try to explore the legal framework over the originality or the authorship of the AIGC. Yeah, thank you very much for your question again. Yeah, thank you.
Thank you very much, Yiheng. Yes, I see Dr. Zhu. Please go ahead.
Yes, thank you so much for the clarification. It's great. Can I make a quick comment on the AI-generated image using your prompt? So it said you generate an oil painting, religious painting in the style of Vermeer. But I don't think the AI is doing a great job here. It does not appear, doesn't look like Vermeer style. So exactly. Think about yes, milkmaid. So that's why I'm thinking AI also has its limit. So we probably can be frank about this. So how we think about kind of between the hype and the real capability of AI is doing. So if the AI is not that capable of kind of faking human authorial work, so that's the limit. So we can just be frank and address that issue.
Yes, can I like further confirm the questions is about like whether AI's like about the AI's capability of like faking the styles of like the human authors? Is the questions about this, please?
Yeah, so maybe I'm not asking a very well-framed question, just a kind of observation and showing the AI at the moment probably is not always doing the things right, so it can get hallucinated. Exactly. Yeah, so
yeah. Exactly, like when we try to like ask AI to like when we try to like do such experiment, like ask them to create some maybe paintings or maybe something else like in the certain styles, like for some of them like they can fool a certain amount of peoples and you know, ordinary peoples, and there also exists like some experiment, like a double-blind experiment conducted by maybe Sony laboratories in Paris, and they conducted the similar like experiment, show the AIGCs in the styles of Bach, and show them to the college students from the musical college, and it cannot be distinguished from those of real Bach musics. So it may be, I think the capability of like faking something is based on the capability of some specific AI models themselves, or something else that I'm not quite sure. But yes, what we have to admit that the most of those AI models that are released to the public is mostly used for the entertainment purpose instead of the business purpose. Although there is some AI models that are used for the business purpose, like we mentioned in the film The Brutalist, and they are using the AI to further polish the Hungarian accent, and this is just assistance instead of just create something out of nothing. So yes, like we mentioned, this is a rapid changing area, and there is a long way to go maybe in the future, so we can find more things for us to research. I think that would be interesting. Yeah, thank you.
Well, thank you very much. I think we're going to draw it to a close here. There don't seem to be any other hands up, but it was really a fascinating discussion, and it brought out how many different shades of grey there are all over the place in this particular discussion. So thank you very much for stimulating paper, Yiheng, and to Dr. Chen, Dr. Pinar, and Jose for your valuable comments, and everybody else who participated by being present here. Just want to mention that the Global South Network warmly welcomes PhD students from any discipline and from anywhere in the world to present their projects and get some feedback. And anyone who's interested in doing that can contact Dr. Norman Rayat at the email address that I think is provided to everybody, and that's now in the chat box. So our next meeting is at the same time next week, when the guest speaker will be Gordius Turia Singura, who's a PhD candidate at the School of Law at Makerere University in Uganda, and who will present their project entitled Analyzing the Scope and Content of Article 8A of the 1995 Constitution of the Republic of Uganda. So that will be on the 19th of February at 3 p.m. UK time. So goodbye then for now. Have a good day, and thank you again for all your contributions.
Thank you very much.
Bye-bye.
Thank you. Thank you.
Thank you.